The courtroom was still not in silence, but in suppression, a kind of quiet only federal courtrooms know, a kind of stillness that comes from power unspoken but omnipresent. Cameras weren't rolling, but the nation was watching through. Every transcript, every tweet, every leak that would inevitably surface. Washington, D.C. Pretrial motions, United States v. Navarro et al. Judge Tanya Chutkan, robe ironed flat like her courtroom demeanor, presided from the bench. Her expression, unreadable. Her voice, up until now, clinical. The proceeding had taken its expected course: debate over admissibility of evidence tied to former Trump advisor Peter Navarro's communications around. January 6th, legal teams spoke with mechanical clarity. Then came the shift. Representative Jasmine Crockett had filed an amicus brief, invited but not unwelcomed by statute, questioning whether the federal court had maintained a consistent standard in defining incitement and threat to democracy. Her brief cited a legacy of selective prosecutions, historical precedent, comparative legal outcomes for non-white defendants charged under similar statutes. Post-9/11s and during BLM protests? No. One expected her to attend the hearing, and no one expected what came next. Chutkan, reviewing the motions aloud, paused mid-sentence as her eyes landed on the final paragraph of Crockett's submission. She closed the binder, looked up, then said, with no warning, no smile, no hesitance, "This is a courtroom, not a campaign stage. And you, ma'am, are not on trial yet." The oxygen seemed to vanish. A ripple of invisible electricity cracked through the room. Prosecutors looked up. Defense attorneys turned in unison. "Want to miss a word?" Jasmine Crockett remained still. No flinch, no smile, no visible anger, just a long breath. A single blink. And then, with terrifying grace, she rose. She was not the defendant. She was not the counsel. She was not the judge. But in that moment, she owned the floor more than anyone else. And when she finally spoke, her voice was not loud, but it carried. Then, let the record show, when black women speak about injustice in a courtroom, we are told we belong in one, not as witnesses, not as lawmakers, but as defendants. And that's exactly the problem, Your Honor. No outburst. No applause. But the court froze not in chaos, but in reckoning. In this case, this courtroom, and this judge would never return to business as usual. This wasn't the first time. Jasmine Crockett had been underestimated. Weeks before the hearing, she had quietly collaborated with a coalition of civil rights attorneys and legal scholars to draft an amicus brief that would thread a needle most lawmakers wouldn't dare touch: the racialized application of incitement laws in modern American courtrooms. At its surface, the brief appeared technical pages of case citations, constitutional arguments, historical precedent. But underneath, it was a slow-burning indictment of the very stage it was submitted to. She referenced Holder v. Humanitarian Law Project, Brandenburg v. Ohio, and United States v. Ahmed Abu Ali Qassas, where political speech crossed the blurred line into prosecution. But the consequences were wildly disparate depending on who was speaking. One section read plainly, "When speech is prosecuted without consistency, it ceases to be lit, becomes performance." And history has proven who most often becomes the target audience. The brief wasn't headline-grabbing, was calibrated for impact without spectacle. But inside the legal establishment, it detonated quietly. Conservative watchdog groups condemned. It is partisan grandstanding wrapped in legalese. Anonymous judicial clerks leaked warnings to media blogs. Right-wing PACs sent letters urging Judge Chutkan to strike it from the record. Still, the brief made it to her bench. And Crockett, knowing it had ruffled the very circuits of power, showed up in person, not to protest, not to grandstand, to bear witness. To stand beside the words she wrote is dare the system to respond. And respond it did, with a veiled warning, disguised as a reprimand. You are not on trial yet. But what Judge Chutkan failed to see was that Crockett's brief wasn't asking for the court to punish anyone. It was daring it to look in the mirror, and the mirror blinked first. Judge Tanya Chutkan had spent her career walking a judicial tightrope, never flinching, never leaning too far in either direction. On paper, she was everything America said it wanted in a federal judge. Ivy League, former public defender, unshaken in high-pressure trials. She'd earned her reputation by handing down harsh sentences to January 6th defendants, resisting Trump's legal acrobatics, and refusing to back down under political fire. But for all her courtroom steel, she never raised her voice. She didn't have to. Until now, the outburst toward Crockett Sharp, personal and publicly barbed, was out of character. Those who knew her were stunned. Those who didn't assumed she had finally shown her bias. And right-wing media leapt at the chance to frame the moment as a fracture. The activist judge versus the radical congresswoman. But that binary was false, because this wasn't about bias. It was about control. What Judge Chutkan felt, though she'd never say it aloud, was ambushed. Crockett hadn't broken courtroom rules. She had followed every legal path. But the spirit of what Crockett had done was unprecedented. She brought an insurgent logic into the courtroom, one that didn't bow to judicial formality as virtue. One that dared to implicate not just the defendants, but the stage itself. Chutkan had built her entire authority on the idea that law was enough. That being principled, precise, and stoic was justice in action. Crockett, without yelling, without even testifying, challenged that to its core. And for a brief second, a blink in an otherwise perfect record shot, Kuhn snapped. Because what she was facing wasn't a legal challenge. It was a moral confrontation wrapped in constitutional cloth. And for once, she wasn't entirely sure she was on the right side of it. The phrase didn't land like a gavel. It landed like a gunshot, quiet but final. You are not on trial yet. There it was again, federal judge in open court, aiming a line like a loaded weapon at a sitting member of Congress. The phrase was thinly veiled, soaked in implication, and thick with something unspoken power, trembling under pressure. No one moved. Not the court reporter, not the marshals, not the defendants, and not Jasmine Crockett. She took a slow step forward, not toward the bench, but toward the center of the room, her hands steady at her sides. The silence stretched, not from fear, but from expectation. It wasn't a hearing on Capitol Hill. It was federal court, but Crockett had never needed a mic to make a moment echo. Her voice came low, calm, every syllable a scalpel. And let the record show, when black women speak about injustice in a courtroom, we are told we belong in one, not as witnesses, not as lawmakers, but as defendants. And that, Your Honor, is exactly the problem. Not defiance. Not outrage, precision. Chutkan sat frozen behind the bench. She didn't interject. Couldn't. The room was too still, too awake. Crockett continued. I did not come here to politicize your court. I came to submit a brief grounded in precedent. But what you just delivered to me was not precedent. It was warning. She stepped back, eyes steady, and I don't. Fear warnings, Judge. I recognize them, because I've read too many court transcripts where warnings like yours turned into convictions against people who looked like me, who spoke like me, who dared like me to question the illusion of neutrality. A single cough echoed from the gallery, someone stunned back into breath. Still, Crockett didn't raise her voice. That was the point. She didn't have to win the moment. She had to freeze it in time. And as the seconds dragged on, it was clear. The courtroom wasn't hers to command, but now it wasn't Chutkan's either, for all her judicial experience. Judge Tanya Chutkan had not expected to lose the room, but she had. Not through scandal, not through error. Through a truth delivered without anger. There was no procedural objection to Crockett's words, no legal motion filed, no contempt ruling that would stick. Everything Jasmine Crockett had just said sat perfectly and comfortably within the rules of the court, and that's what made it unbearable. Chutkan didn't respond. She couldn't, not immediately. Any reply now would sound defensive, reactive. She'd lost the offensive posture. Her bench, elevated in marble and distance, suddenly felt eye level. The defense team, seated just feet away, shifted uneasily. They'd hoped for a courtroom moment that would cast doubt on the government's objectivity. It's not a televised reckoning about systemic bias they were unequipped to counter. The prosecutors sat still, but stone-faced, internally recalibrating. This wasn't supposed to be the story. Crockett had just reframed the entire hearing without touching a single piece of evidence. And Crockett, she didn't gloat. She didn't smirk. She simply returned to her seat. Deliberate, silent, is cold. Because this wasn't about a line, it was about the gaze that followed it. The way the entire room had turned to her not as a guest, but as a threat, not because she broke decorum, but because she challenged its sanctity. For decades, power in American courtrooms has depended on the idea that those who question the structure are agitators, not advocates. That silence is professionalism. That restraint equals respect. But Crockett had wielded restraint as power, and in doing so, she didn't. Just flip the courtroom dynamic. She rewrote the rules of confrontation. Now, no one was speaking. But everyone was watching. They weren't watching the judge. They were watching the woman who refused to flinch. The docket had moved on officially, but unofficially. The courtroom had changed frequency. No one said it aloud, but everyone could. Feel that the judge's authority had been disrupted, not by chaos, but by clarity. Crockett's words, still echoing in headlines and across legal Twitter, had created a vacuum. And vacuums, in court, tend to demand something to fill them. That something came the next day. In the form of a man named Dr. Elias Monroe, a constitutional scholar from Georgetown, subpoenaed previously by the defense to contextualize political speech and pre-trial evidentiary standards. He wasn't a showman, no theatrics, no ideology in his tone. Just facts delivered with the gentle precision of someone who knew his words would ripple far beyond the transcript. He referenced Brandenburg v. Ohio, the standard for when inflammatory speech loses First Amendment protection. Then he pivoted unexpectedly. "Your Honor," he said softly, eyes meeting Chutkan's directly. "It is legally relevant to acknowledge that incitement historically. It's never been a raised neutral charge in the United States. From the criminalization of black radical speech in the 1960s to the selective prosecution of protesters post-9/11s, enforcement has mirrored power, not principle." Chutkan did not interrupt. Monroe continued, "I'm not here to defend Representative Crockett's tone. But I am here to say that her brief and her statement are not anomalies. They are constitutional reminders that law does not exist outside of history. And history in this courtroom just made itself known." A pause. No objections. Even the defense attorneys who brought Monroe looked uncomfortable, unsure if this helped or hurt their case. But Crockett sat still in the gallery. Unreadable. This wasn't about her anymore. She had become the context in the courtroom. Was no longer just trying a case, it was now defending its own credibility. By the time the court recessed for the afternoon, the moment had already been clipped, captioned, and distributed to millions. The quote was everywhere. Let the record show. Crockett's words were replayed on cable news with opposing tones. Fox News labeled her a radical opportunist, hijacking federal proceedings to score political points. Newsmax ran a lower third that read, "Representative Crockett threatens federal judge on camera." Judicial Crisis Network launched a digital ad. Is this the new left? Congress threatens the courts, but progressives saw something different. MSNBC praised her restraint. A Pod Save America called it the single most precise courtroom takedown of the decade. Twitter X turned it into a viral thread dissecting systemic judicial bias. Academics began reposting clips, adding historical context. Even law students at Harvard and Howard broke it down frame by frame, citing stare decisis and structural inequity in their takes. But it wasn't just opinion. Public pressure began to mount. Legal watchdogs called for a transcript release. The National Bar Association issued a statement defending the legitimacy of her brief and the decorum of her response. Civil rights groups began drafting their own amicus briefs for upcoming trials, citing the Chutkan-Crockett exchange as a case study in institutional deflection. Chutkan, for her part, remained silent. She did not address the comment. She did not clarify her intent, but her silence was now loaded. not with dignity, but with uncertainty. Crockett, meanwhile, leaned into the fire. In a quiet tweet, she wrote, "I've spent more time in courtrooms defending truth than many have defending power. I'll take that ratio any day. No hashtags. No interview circuit. Just presence." She wasn't riding a wave. She was steering it. In the courtroom, the whole idea of who it served and who it silenced had just become the new national stage. The courtroom doors had closed, transcripts sealed, the docket moved forward. But inside the federal courthouse on Constitution Avenue, silence was no longer control. It was tension. Behind closed doors, Judge Tanya Chutkan sat in her chambers, flanked by her clerks. The blinds were drawn, the lights dimmed. On her desk sat a pile of case law, a half-drunk cup of tea, and a printed copy of Jasmine Crockett's amicus brief, now marked with red tabs and margin notes. She hadn't spoken for nearly 10 minutes. When she finally did, her voice was low, calculated. She didn't attack me. Not directly, but she knew exactly what she was doing. One clerk nodded cautiously. Another avoided eye contact. They'd never seen the judge shaken until now, according to a later leak from a court. Assistant later confirmed off record. To several legal reporters, Chutkan told her staff, she didn't come for a moment. She came to fracture something. She did. She made me the face of a system she's been building a case against for years, and I walked straight into it. The assistant who leaked the conversation under anonymity said the judge showed something rare. Reflection, not regret, not outrage, but recognition. Another quote leaked days later, "I spent decades believing impartiality was the shield, but maybe it's been a mirror all along, and today it cracked." That quote hit headlines harder than any motion filed that week. Suddenly, Judge Tanya Chutkan wasn't just the jurist who snapped at a congresswoman. She was a human being, now caught in a tectonic rift between institution and introspection, publicly. She still hadn't spoken, but the leak gave the nation a glimpse of something rawer than a press conference ever could call in doubt. And in a federal, Judge doubt is both the most dangerous and the most honest thing of all. By the time Monday rolled around, the Hill was no longer whispering about the Crockett-Chutkan clash, was mobilizing around it. Representative Cori Bush took the House. Floor first. What happened in that courtroom wasn't just disrespect. It was a warning, the kind of warning black women have heard for centuries. Sit down, stay quiet, don't disrupt the order. Well, we're done sitting. Ayanna Pressley followed with a statement on social media, "The courtroom is not neutral ground." Jasmine Crockett didn't disrupt it. She reminded it what justice sounds like when spoken without fear. Even moderate Democrats, initially quiet, began issuing carefully worded statements defending Crockett's legal standing and constitutional right to sub and speak on amicus briefs. As a member of Congress and former defense attorney, but the momentum didn't stop with words. Civil rights organizations sprang into action. The ACLU, NAACP Legal Defense Fund, and even Human Rights Watch began referencing the Crockett-Chutkan moment in their filings. For upcoming cases involving political speech and selective prosecution, one brief cited it as a modern-day example of institutional reflex when power is challenged by both race and rank. Meanwhile, across the country, federal circuit courts received over 40 new filings citing inconsistent prosecution patterns in political speech cases, many using the language and framework outlined in Crockett's original brief. What began as a courtroom scolding had evolved into a legal movement, but inside Jasmine Crockett's office on Capitol Hill, there was no victory lap, no press tour, just a whiteboard with one sentence scrawled across the top. We weren't disrupting justice. We were describing its limits. For Crockett, this wasn't just about vindication. It was about traction-building pressure, where courts could no longer pretend neutrality was enough. The question was no longer whether she had crossed a line. It was whether the system had ever drawn that line for anyone else. The courtroom looked the same marble benches, same lighting, same soft hum of government HVAC overhead, but the atmosphere, different. No longer tense, now reverent, because Jasmine Crockett had returned, not summoned, not subpoenaed, invited, in a rare procedural move. The court had opened the gallery to legal observers for a follow-up hearing. Tied to procedural transparency, and though her role was strictly non-participatory, every head turned when she entered. She didn't wear power. Oh, she moved in it. Quiet, confident, dressed in courtroom black, no jewelry, no visible emotion, just presence. The defense glanced back. The prosecution straightened papers it didn't need to, and then after 2 hours of technical testimony, Judge Chutkan paused, looked up from her notes, and did something no one expected. She spoke directly to Crockett. "Congresswoman Crockett," she said slowly, tone careful, "would you care to clarify your previous statement, for the record?" No gasps, just stillness. Crockett stood her. The voice didn't change volume, didn't add heat. "Your Honor," she said without blinking, "the record needs no clarification, only courage to read it." The air in the courtroom collapsed into silence. But it wasn't emptiness. It was gravity. Every clerk, every attorney, every reporter felt it. The subtle violence of a line that left no room to maneuver. No escalation. No dramatics, just precision. Even Chutkan froze. Not in fear, but in full understanding of what had just happened. She had given Crockett a chance to soften the blade. Instead, she let it land again. Cooler, deeper, quieter. A moment later, the judge nodded once. Not approval, not defeat, acknowledgement, because Crockett hadn't come for vindication. She'd come to remind them all that the truth doesn't require permission to stand, and once spoken, it doesn't leave, it lingers.